Hello, everyone. It's Michael Lower here. So our moderator, Professor Taryn Aurora, has had some technical problem. So just for now, I'll take over and introduce our first speaker, Professor Isabelle Giraudou from the University of Tokyo, who's going to speak about curriculum design for the Anthropocene, a discursive approach to case-based legal education. If you've got questions, please put them in the chat to me and I'll read them out to Professor Giraudou. Over to you.
Thank you very much. First of all, I would like to thank the organizer of this conference. Actually, this is the second time that I joined the Directions in Legal Education conference, and so I'm very glad to meet you again, although this time it's on Zoom. So I'm going to share a few slides. Here we are. I hope you can see them properly. So my presentation today addresses the question of how legal education can engage with the Anthropocene. I will briefly explore the potential issues facing law schools within Asia in the adoption of the Anthropocene as a new component of teaching and learning. Then I will focus on the need for and the emergence of innovative teaching and learning practices, which I propose to characterize as case-based legal education for the Anthropocene. But to begin with, a few words on the groundbreaking hypothesis of the Anthropocene. The Anthropocene, as you may know, defines Earth's most recent geologic time period as being human influence or anthropogenic, based on overwhelming global evidence that atmospheric, geologic, hydrologic, biospheric, and other Earth system processes are now altered by humans. And the underlying hypothesis of the Anthropocene is that in view of this increasingly inextricable interfusion of nature and human society, any clear divide between a subject and object, ecosystems and social systems is no longer viable. And it is not so much the categories themselves that are obsolete, but rather the perception of humans and non-humans' nature as neatly bounded and distinct realms of reality. Initially delineated by various scientific disciplines, including atmospheric chemistry, climatology, oceanography, geology, the Anthropocene has been progressively sparking a wide range of interdisciplinary conversations on the state of the global environment and is now engaged with across diverse academic fields. Although to a still limited extent, law has been taking part in this movement with several academic works addressing the implications of the concept for either the legal discipline in general or environmental law in particular. And this, in turn, raises a number of crucial challenges for academia, hence the recent call for radical reorientations of curricula, practices of engagement with communities outside the academy, reconceptualizations of what knowledge itself is, and a rethink of how this knowledge is being produced in the Anthropocene. Scholarship includes work on the significance of the Anthropocene for higher education, particularly in regard to the issues posed by the Anthropocene for the practices of teaching and research, as well as the ethics and philosophies underlying those practices. Again, the field of law is no exception, with a growing body of contributions exploring connections between the Anthropocene and law, including legal education. And so my presentation will follow this nascent scholarship on the integration of the Anthropocene into legal education. In so doing, however, I will also expose some aspects of my most recent research project, which addresses the emergence of new legal practices in the Anthropocene Japan and focuses on innovative case-based legal education. Sorry, I'm trying to, yeah, here you are. Regarding the conceptual framework, so the introduction into legal education of the Anthropocene as the new component of teaching and learning raises several issues, mostly in terms of content, teaching tools, and a subject placement within the overall legal education curriculum. Regarding these different aspects, and as recently discussed, for example, by Jonathan Liljeblad from the Australian National University, a distinction can be made between so-called thin and thick approaches to the introduction of the Anthropocene into legal education. In any event, at the conceptual core of the Anthropocene centers on the relationship between nature and human society, any attempts to integrate the Anthropocene into legal education necessarily require interdisciplinary teaching encompassing law and environmental sciences. So first, concerns over content necessarily revolve around the identification of what a law school should include in teaching the Anthropocene with respect to both the knowledge and skills that students are expected to learn for their degree. And in this regard, while thin approaches would restrict treatment of the Anthropocene either to its appearances as a concern in laws and legal issues, or its presence in future legal practice, thick approaches, by contrast, would seek to offer a broader context going beyond the significance of the Anthropocene for the creation and practice of law to further include academic and professional perspectives about the Anthropocene, differences in discourse over the Anthropocene across multiple disciplines, and finally the place of the law in larger holistic understanding of humanity and the environment. But the integration of the Anthropocene into legal education also raises questions in terms of teaching tools. And here again, a distinction can be made between thin and thick approaches. Thin approaches in that they narrow the expectations of what students should learn about the Anthropocene to some legal aspects in particular, make it more feasible to avoid interdisciplinary choices. By contrast, thick approaches, as they seek to broaden students' understanding of the Anthropocene to perspectives outside the law, pose a larger burden in teaching capacity that calls for a distribution of teaching across multiple disciplines. And finally, similar problems can be identified regarding how to locate the Anthropocene in the legal curriculum. In fact, the use of dedicated courses while contributing to raise awareness among law students might also run the risk to isolate the Anthropocene as a subject from other components of the curriculum, making it quite difficult for students to comprehend the scale with which the issues of the Anthropocene can pervade the legal field. Additionally, analysis directed towards the implementation of the Anthropocene as a subject in Asian legal education requires some attention to regional, political, economic, and sociocultural pressures that might influence law schools. And this, of course, also applies to Japanese law schools. Hence, the need to complement the theoretical framework discussed here with additional empirical studies that record and collect how law schools are planning to bring or have started to integrate the Anthropocene into their teaching programs. In this regard, I would like to focus the discussion on case-based legal education in particular. Precisely, my most recent research project explores from a specific perspective the practical and theoretical conditions under which legal education can engage with the Anthropocene through experiment. With a view to enriching the discussion on what to think like a lawyer means and implies in the current era, this research project examines the opportunities for and the barriers to the development of climate crisis lawyering in Japan. It assesses in particular the extent to which innovative case-based legal education might contribute to progressively open up legal reasoning to planetary modes of thinking and subsequently consolidate climate disaster law as an emergent area of legal knowledge and practice in Japan. So while considering the relevance and meaningfulness of the theoretical framework discussed in the first part of this discussion, this presentation, my project further elaborates on the notion of legal imaginaries and explores its possible development and applications, in particular through what we call speculative judging as an innovative teaching and learning method. In a stimulating discussion on the emergence of new legal imaginaries in the Anthropocene, Anna Greer contrasts the dominant imaginary underlying law of the Anthropocene with an imaginary reaching towards laws for the Anthropocene. And in so doing, she explores the possible development of what she calls symbiotic normativities as ways of co-living and co-organizing in the face of the catastrophic implications of the Anthropocene emergency. In that sense, legal imaginaries can be discussed in relation with the assemblage concept, understood by some critical environmental legal scholars as a way of incorporating non-human and other than human agency. In fact, for those critical environmental legal scholars joining the ongoing discussion on law and the Anthropocene, the debate anthropocentrism versus ecocentrism sounds outmoded. And in this sense, for example, Andreas Philippopoulos-Mihalopoulos insightfully observes that the Anthropocene has exposed the grand paradox of the absence of center. Precisely this approach fosters a new mode of thinking, allowing disciplines such as environmental law to question accepted boundaries and start experimenting with new assemblages that include different materialities. Philippopoulos-Mihalopoulos precisely considers that we are always in an assemblage with the planet, and he further emphasizes that the boundary between a body and its environment can no longer be taken as a given. However, at the same time, the author makes clear that there is no center, yet there is difference. Hence, the need for critical scholars to consider both and simultaneously the indistinguishability between bodies in reaction against an enduring human exceptionalism and the de facto emergence of different bodies, hence a needed return of anthropos as a new political and legal body. Precisely, and as Philippopoulos-Mihalopoulos further explains by drawing on assembly thinking, the responsibility regarding planetary degradation changes depending on where each body is situated in the assemblage. And in that sense, what he calls situated environmental law should help humans assume their responsibility in relation to their position in the planetary assemblage. But the question is then for us, what is exactly the potential of these critical approaches focused on alternative legal imaginaries and assemblages regarding the possible integration of the Anthropocene into legal education? And here I would like to reflect on the didactic value and meaningfulness of the creative use of legal cases in the classroom. I will focus the examination on critical pseudo-legal performances such as judgments projects. Judgments projects basically consist for involved participants in either rewriting judgments or constructing hypothetical and even futuristic judgments. In so doing, they seek to open up the space of judicial reasoning to different narratives. In most judgment rewriting projects, participants have reshaped past judgments, drawing upon established legal principles, and in so doing, they highlight the transformative possibilities in existing law, with a focus on common law. Used in the classroom, judgments project allow students to progressively get more familiar with the possibility of reading a judicial decision from at least two perspectives, as it has been adopted in a given jurisdiction based upon existing environmental laws, and as it can be deconstructed, reinterpreted, and rewritten from a critical perspective, for example, the so-called wide law perspective, which itself can draw on fragmented pieces of domestic legislation and emerging regulatory instruments. In so doing, students both scrutinize the inadequacy of existing laws and explore how a reversal in perspective helps address issues concerning a variety of communities and life forms. The most recently adopted Anthropocene Judgments project seeks to go a step further. As described by its proponents, the Anthropocene Judgments project is intended to be an interdisciplinary, collaborative, visionary initiative, a collective effort on the part of legal scholars, writers of speculative fiction, literary scholars, and climate scientists to anticipate what may lie ahead. And in fact, rather than adopting the more conventional methodology of rewriting existing judgments using accepted legal principles, participants to the Anthropocene Judgment Project will engage in futuristic modeling and write judgments for the future. Another novel aspect of this initiative in the context of critical judgments projects is indeed its interdisciplinary scope. In a nutshell, the main aim of its participants is to construct innovative pathways of legal reasoning to address the novel socio-legal and environmental challenges of the Anthropocene. And as again underlined by its proponents, this project is designed to envisage and preempt common law responses to the complex issues, wicked problems, and existential challenges of the Anthropocene. So my own research project actually builds on a critical judgments project in general, and this most recent Anthropocene judgments project in particular. I'm currently exploring how and the extent to which the area of future hypothetical judgments is ripe for exploration by students as well. And at this very preliminary stage, my principal aim is to assess how students prepared to engage with the imaginings of writers of speculative fiction and the future modeling of scientists could start experiment with the transformative capacity of the process of judging in the Anthropocene. So indeed, a research in slow progress. Thank you very much for your attention.
Thank you, Professor Isabelle. So thanks for this wonderful presentation. And first of all, I would like to apologize for being late because of the connectivity issue. So Isabelle had made her presentation regarding a very relevant aspect in the contemporary times, that is curriculum design for Anthropocene, a discursive approach to case-based legal education. Friends, if there are any questions, please may drop those questions in the chat box, and we will take up the questions. Meanwhile, I would like to introduce Mr. Antonio Mario de Roza from Chinese University of Hong Kong. Okay, so from Isabelle ma'am, there is a question from Mr. Michael Lohr, that how is it possible to give an example of how a judgment might be rewritten? So if you could please take up this question.
Right, so it's important to acknowledge that the Anthropocene Judgment Project is not the first of this type. The proponents of this project before have worked in the framework of the so-called TWAIL Law Judgment Project. And in this framework, they have already worked on a variety of cases, including environmental cases and more specifically relating to climate change. Again, in this Anthropocene Judgment Project, the same proponents, mainly from Australia and working in the framework of common law, are trying to reflect back on the potential of common law regarding climate change and the possibility to use it in the framework of the evolving climate change litigation. Regarding my own courses, I'm not working in a law school. I'm working now in the graduate school of arts and sciences, and basically my classroom is a mixed classroom with students having different backgrounds, some specializing in social society and humanities, and the other part specializing in natural sciences. And we're working with climate change litigation related cases, so adopted ones, judicial decisions which have been adopted, including in Japan. In Japan, we have already a few cases listed as climate change litigation. And then we basically examine the way these cases have been dealt with, the argumentation developed by the parties, the arguments and the reasoning followed by the judge. And then from there, we try to put these adopted judicial decision into a critical perspective based on a few elements already discussed in other classroom in order for those students to get some literacy with a focus on critical environmental law. So it's just a start, and again, it's not in the framework of a law school. Now, my current research project, I have a strong interest in developing some collaborations, including with these Australian researchers, and to work in collaboration with environmental clinics, law clinics. So I'm still in the process of putting in place such collaborations, but with a strong hope that my students coming with this interdisciplinary classroom can connect with one monodisciplinary framework, and this collaboration taking the form of a legal clinic, new kind of environmental clinic.
So thanks, Professor Isabelle. I hope Michael must be satisfied by the reply. And now I would like to call upon Mr. Antonio Mario da Roza, affiliated to Chinese University of Hong Kong, who will be speaking on kinesthetic and reflective, applying the principles of adult learning in judicial training. Over to Mr. Antonio.
Good afternoon, everyone. My name is Antonio da Roza, and I'm very pleased to have this opportunity to speak to you today at this conference on teaching and learning in law. Just a little about myself before we begin. I am currently a part-time PhD candidate at the Law Faculty of the Chinese University of Hong Kong, and I serve as a director at the Hong Kong Judicial Institute, which is responsible for judicial training in Hong Kong. My presentation today is on the application of adult learning principles in judicial education. This may differ somewhat from other presentations you will have heard during the course of this conference. But as there is a growing focus on continuing professional development in Hong Kong, I think it is a valuable discussion to have, to consider how different the needs of adult professional lawyers are from those of law students. My presentation is going to specifically focus on an experience I recently had in providing some training to the Judiciary of Nepal. Although this experience obviously builds on my work at the Judicial Institute to an extent, I'm really speaking today as a PhD candidate. Generally speaking, in my role as director of the Judicial Institute, I assist with the design and preparation of training and materials, but I'm never the one to provide the training, as it is a well-established principle of judicial training that judges are the ones who lead other judges when it comes to training. My presentation to the Judiciary of Nepal was the first time where I not only designed and prepared the training and materials, but delivered it as a guest speaker as well, alongside some of the professors here at Chinese University. As you will see here, I presented 3 sessions to the Judiciary of Nepal. But before I get into the details of the 3 sessions, we might first want to take a look at the principles that are applicable to judicial training. Judicial training engages 3 levels of learning. The first is the general principles that are applicable to adult learning, Andragogy, as opposed to pedagogy for students. I've set out here the 7 principles that sum up Andragogy, but I want to highlight 3 of these in particular. The first is that adults only learn what they feel they need. Adults are very practical in how they approach learning. They want to know from the outset how it will help them, and how it is relevant to them, and if it meets their purposes for pursuing the learning. Adults tend to learn by doing. This brings the kinesthetic part of my presentation sharply into focus. That adults learn through active practice and participation, which helps them integrate skills. Finally, adult learning focuses on problem solving. Whilst pedagogy teaches sequentially, the starting point for adult learning tends to be a problem, and the learning process works towards a solution. This is very important to bear in mind in designing adult learning. For there to be successful learning experiences, there must be meaningful engagement from the learner's perspective, such as posing and answering realistic questions and problems. This creates a longer lasting and stronger impression of the knowledge being taught. The next level of learning, beyond the general principles of adult learning, are principles of continuing professional development. Continuing professional development is a type of adult learning that helps to ensure the learner is or continues to be proficient and competent in their profession, furnishing skills that can help the learner do their job better and progress their careers. The distinction that can be drawn between general adult learning and continuing professional development is that CPD is very much needs-driven, and what is learnt is fully intended to be applied in a very practical way, with the expectation it will enhance the learner's performance. Thus, the needs of a CPD learner are likely to be quite specific, and the learner themselves will usually have a pretty clear idea of what they want to know. Where CPD learners need help is guidance and assistance in structuring their continuing professional development. A key aspect of enhancing performance is the learner reflecting on what they have learned. Only through reflection are they able to alter their practices for the desired improvement. CPD is thus less didactic or an authoritarian model of teaching and more a process that is based on facilitation and self-directed learning. In this regard, CPD can be broken down into three types: structured or active learning, reflective or passive learning, and self-directed or unstructured learning. I'm going to focus here on structured learning because that is the form of training that my presentations to the Judiciary of Nepal took. Structured learning involves interactive and participation-based study and includes training courses, workshops, seminars, and conferences such as these. This may be contrasted with passive learning, which involves no participant interaction, such as reading of news articles and case studies, listening to podcasts, and so on. This differs from self-directed learning, which is unaccompanied CPD activities. That is, the learner seeks the materials themselves rather than being told or directed towards them. There may be some overlap between the medium which reflective and self-directed learning use. Turning now to the third level, it is increasingly acknowledged that judicial training is its own niche of adult and professional training, as judges demonstrate their own preferred learning styles and use specific preferred learning practices. The quote that I have placed on this slide is derived from a Canadian study on judges as learners, which found that there were 4 factors that shaped judges as learners: their appointment process and tenure, their preferred learning styles and preferences, the constraints of judicial education, and their reasons for participating in continuing education. To these 4 factors, I would also add a factor that informs their motivation as well as their learning process: their sense of public duty. For these reasons, judges are generally self-directed learners who exhibit intensely short-term, problem-oriented approaches to their learning practices. However, although self-directed, judges do not necessarily like to learn alone. Instead, collegiality is also an important part of the training process, as judge learners need to have interaction, exchanges of ideas, and be challenged by colleagues' thinking. Thus, in judicial training, there needs to be a strong element of constructive interaction and learning from colleagues by way of problem-solving workshops and small group discussions. These specific characteristics of judicial learning have led to the observation made in the Canadian study of a trend towards competency-based judicial training. That is, not just focused on law and procedure, but on skills and attitudes in the act of judging. Building on the idea of a competency-based approach, a study in the UK suggested that there are three purposes for judicial training. Preparing judges for performing duties, which may not be limited to new judges, but also judges moving into new roles, for example, through promotion. The ensuring of greater consistency between judicial decisions, and, of course, keeping judges up to date on the law, other knowledge, and other methods. The importance of these purposes has meant that there is an increasing interest and an increasing public interest in judicial training. The same study in the UK also identified three levels of judicial knowledge. At its most basic level, judicial training provides information on substantive law, including updates to case law and legislation. Beyond this basic level, we get into judgecraft, which are the skills involved in the work of judging, such as judgment writing, sentencing, handling different kinds of evidence, different kinds of witnesses, and different kinds of litigants. The most sophisticated level addresses changes in attitude, such as helping judges recognize their own biases. For the purposes of the training I designed for the Judiciary of Nepal, for the most part, we were concerned with the first two levels, although one could argue we got into the third level. I was asked to lead 3 one-hour sessions on the first day of the program for the Nepalese judges. This would be the first time I would be using Zoom to teach, and given that the presentation would be broadcast to a large number of judges in different locations, the prospect of a highly interactive session was low. Further, having decided on the topic of recusal, the question was how to make it of interest and relevance to the Nepalese judges. I decided my first session would need to be a review of the principles of recusal. This would help lay down a foundation on which I could build on in the next 2 sessions. The main challenge would be how the material could be approached so that the judges would have a takeaway of interest and not be bored by a review of the general principles. The second session would be aimed at reflecting on the material that was covered in the first session in a more detailed way. The issue here was how to keep the judges interested in this analysis of the cases on recusal. The final session would be on practical application, the challenge of which was how to avoid overlapping content with the second session. One can thus see how easy it could be to create sessions that were potentially boring and turn off the participants if one did not approach the design with care. The first session was actually relatively straightforward, so I opted to narrate the development of the common law principles on recusal and bias from a historical perspective. One of the key ways we have found is effective in creating a deeper impression of the material is to understand how the law has developed over time, rather than to simply talk about principles. In the case of recusal, due to the divergence in the approaches between England and other common law jurisdictions, primarily Australia and Canada, there was a relatively interesting story to tell. Out of those materials, the key question was, what would be the main takeaway for the judges? What new knowledge could there be that they would find useful? I decided that I would introduce the idea of a way to approach the types of scenario judges might find themselves in to determine whether or not recusal was called for. Under the English approach, there was a Court of Appeal case which set out a lengthy list of examples where recusal of the judge would or would not be necessary. A similar approach was taken in the commentary to the Bangalore Principles. However, in Australia, a High Court of Australia case suggested a number of categories of case for the purposes of recusal. My idea was to take the examples from the English case and categorize them according to the categories suggested by the High Court of Australia. In this way, the judges would have the benefit not only of the categories of cases of recusal, but specific examples in each category illustrating when recusal may or may not be required. This would help set the scene for the second session. The second session built on the first in two ways. First, it was a detailed review of the most recent cases of recusal from England, Australia, and Scotland, bringing the judges' knowledge up to date. Second, it also served as an illustration of how the categorization of examples introduced in the first session could be practically applied to the facts of new cases, to examine whether or not recusal in those situations was called for. Finally, the session concluded with an in-depth examination of a mock judgment which I had drafted. This mock judgment was intended not only to fill the gaps in the categories that had not been discussed, but was designed to be more difficult by presenting a case which could fit into more than one category. The question that was raised to the judges was how they would rule on an appeal against the mock judgment, which rejected an application for recusal. The third and final session then examined the mock judgment in detail, this time not from the point of view of applying the principles of recusal, but from a judicial reasoning and writing point of view. This approach really dissected and broke down the entire judgment, from its structure to the reasoning it presented, to examining its conclusions under the deductive process by the use of syllogisms. Here, the multi-layered design of the three sessions becomes clear, as does the gradual increase in difficulty from the first session, which was a review of substantive law, to the second session, which focused on the application of substantive law, to the third, which was focused deeply on a number of different aspects of judgecraft, including judicial writing and reasoning. The three sessions actually covered a lot of material. That too was by design, as the limited amount of time required a rather intense delivery. What was interesting was that although not many questions were asked immediately after the three sessions, it was easy to tell from Zoom that the audience was relatively engaged. In this sense, one got a much better feel for how people were responding, as one could see them quite clearly on camera. However, what was enormously telling was the next day, when the program had moved on to other topics. At the conclusion of the first talk on that second day, the judges immediately raised questions about recusal. This, to me at least, showed that they had been engaged and were reflecting on the material covered the day before. I did also receive some very kind comments during the closing of the course, but to me, it was more important that I had been able to successfully trigger some reflection in the audience and keep them thinking about the points I had raised the day before. To me, having taught law students before, the most difficult transition to dealing with adult learning was to come to the understanding that one should not be afraid to design the teaching in a way that is complex and multi-layered. It is far more likely that in reality, adults, lawyers, and judges in particular are going to have to deal with situations that require more than a single level of problem solving. In this regard, it is far more important to trigger self-reflection, that is, to get the learners thinking about things for themselves, because they are unlikely to all reach the desired outcome of learning at the same time. It is likely to take more time to digest and absorb, but if interest is sufficiently piqued, this will trigger further reflection and learning, which will hopefully set them up to better deal with the real-life situations that they encounter. Thank you for your attention. I look forward to hearing your thoughts and comments.
So Mario, it was a very nice presentation full of content and brainstorming, giving the audience the food for thought, and particularly the legal academics, while dealing with the different facets of legal education. And there are many additional takeaways from what Mr. Roza pointed out. He has pointed out though only 2 takeaways, but I feel that there are much more for us to learn and take away from this presentation. So friends, if you people have any question, may please drop in the chat box. Yes, so a question for Mr. De Roza is, on the matter of the judges coming back the next day, is this perhaps reflective of the way judges work? They hear all the evidence and let it sit and then evaluate it. So
I think it is reflective of the way that judges learn, because in my experience, what tends to happen is it's not the same thing as having contact time with law students, where you'll be able to sort of come back the next day or the day after that, or the next lesson, and they will be able to answer questions or ask their questions and bring you back to a topic that you've taught them. For CPD topics, it tends to be very standalone, and this tends to be a little bit counterintuitive when you're designing things, but the truth is they need that time to go away and absorb and think things over. One of the problems that you do have with taking a multi-layered approach is that because there's so much to digest in any one go, people need time to go away, reflect, and come to their own conclusions. So there tends to be a process by which you need to give a bit of time so that the judges or the adult learners can come back to you with their thoughts. So it was interesting because like I said, I didn't get that many questions on the day, but when it came time to actually, the second day, there were a number of other presentations on other topics. The judges wanted to come back to recusal. So that was interesting. And I think with that experience, if I were to design it again, I probably would have a Q&A session for the next day, rather than to have the Q&A just at the end of the session. It's a bit difficult, obviously, especially because there's so little time for judges to actually engage with training because they're so busy in their everyday work.
So thank you, Mr. Antonio. Now, friends, we will take up the next presentation. And okay, so one more, Mr. Antonio, can you please hear us? Yes.
Sure.
Yes, yes. So Michael has raised a question. How did education for attitudinal change emerge in your sessions? May please.
So when I spoke about the 3 levels and the attitudinal change, what we were looking at really was the topic of recusal and bias. And one of the things that was kind of underlying as a theme was really about the approach to bias and identifying how your bias comes across. Particularly in the session, in the 3rd session, where I took them through it was a very detailed session on the mock judgment that I had written. Now that mock judgment, there were some points that were a bit more subtle and some that weren't. One of the things that I wanted to bring out was how judges are expressing themselves in judgments. So I did load the judgment with a lot of emotive language. I also loaded the judgment with a lot of references to the judge themselves as I throughout the judgment. And the idea was really to illustrate how this comes across to a reader of the judgment. And I think at the same time, what I tried to do was to focus the judges' minds, not just on how they were coming across in the judgment, but also how they were thinking as they wrote the judgment about bias and whether or not they could take a more objective or outside perspective to the work that they were doing.
Thank you, Mr. Antonio. So
Thank
now I would like to call upon Mr. Wilson Lee from University of Hong Kong, who will be presenting his views on highlighting the importance of language in legal education. Over to Mr. Wilson.
Thank you, Professor Aurora. Thank you. Let me share my screen now. Hope you can see it. And we'll start presenting. A bit about myself. I'm Wilson. I'm a pre-doctoral fellow at the University of Hong Kong in the coming academic year, and I'll be teaching a few courses in due course. So today I want to highlight on the importance of language in legal education. First, I want to give you a very brief overview about what does it mean to be talking about language and law. So in one sense, we can think about it in terms of different actors. So there are judges, lawyers, interpreters, jurors, which are all engaged in some kind of language process when we deal with legal processes in general. So judges have their oral judicial discourse, and they have judgments which are written and delivered to the parties and to the public as well. There's therefore two kinds of audience in any written judicial discourse. Lawyers drafting written documents to the court, to the parties, and to deliver oral advocacy before the judges, before the jurors, and so on. And there are interpreters at work, which translates among different languages. And of course, there are a lot of issues between equivalence among languages. So we can see in a courtroom, there are different people involved, and there are constant role exchanges between who is the addresser, who is the addressee, who is listening to this conversation, and who is simply overhearing. For example, the audience or the public which is sitting at the public gallery, they hear different things, and there's a lot indeed to discover in this language and law interface. So some background about Hong Kong before I move on to talk about the education courses that I'm talking in the subsequent 12 minutes or so. In Basic Law Article 9, we know in addition to Chinese language, English can also be used as an official language by the government, including the judiciary of the Hong Kong Special Administrative Region. And we have the Official Languages Ordinance, which came into effect in 1974 and extended to court proceedings in 1995, where we have English and Chinese as both official languages in Hong Kong and possesses equal status with equality of use. So in a court proceeding, simply speaking, a judge can use either or both languages. Depends on what he or she think it's the most appropriate language should be used in this legal proceedings. Note, however, this is not a language right. We don't guarantee the right for a person to use a particular language. Rather, we decide, the judge decides which is the most suitable language should be used in a proceeding. And we see in recent years, there's an increasing trend of using Chinese, that is Cantonese, which is because it's the language used in the Hong Kong population, major language, and therefore we see an increase in general, or much more increase since 1995, where the first Chinese case is heard, and then we have a subsequent increase in seeing around 70% or 50% of the cases being heard in Cantonese in recent years. So Hong Kong, as we know, is a common law jurisdiction, but it's also the only common law jurisdiction that uses both Chinese and English as official languages in the legal context. As I said, because Cantonese is the majority language and is spoken by the majority of the Hong Kong population, the judiciary basically acknowledges only Cantonese and English trials. However, sometimes we see that judges and lawyers have difficulty expressing terms in Chinese, because we know in the legal education where we receive so far, legal terms are taught in English and based on common law that we have understood based on, for example, the UK legal system with supplements from the local jurisprudence developed after the handover since 1997. We saw a very frequent code switching in terms of Chinese and English, because we have to consider, for example, legal terms. And there's therefore some kind of fact law distinction where we see legal terms being expressed in English, for example, prejudicial effect, probative value, exclude, conviction, etc. These are expressed in English, but there are also terms that are used in Cantonese, because it is, for example, a Chinese trial or a case on an appeal that we use Cantonese. And therefore, the judge and the lawyer both use these kind of terms in a code-switching way. And the judiciary basically acknowledges the situation without making much rectification. It's not to say that code-switching is bad or it's not, it's difficult or to comprehend. It's not really, rather it helps with the effectiveness, but we have to understand the underlying motivations and the theories behind this. And therefore, linguistics come into play by looking at how, in a, for example, a normalized social structure of a judiciary, of the courtrooms, how do they use language? How do different actors use language? So we see different languages playing a different role. I mentioned the fact or distinction. We quote concepts, evidence, submissions from other languages, Latin words or English words, or Cantonese evidence, but then we write in something else. For example, judgments in Chinese are supposed to be written in modern standard Chinese, the written form, the standardized form. But sometimes can we use the Cantonese in written judgments? How does the language assume their roles in the Hong Kong legal context? This kind of like unequalness or asymmetrical roles is something that could be discussed more prominently in legal education context. And that's why I come into the current landscape of legal education. In Hong Kong, the law students receive some kind of education, although they are all elective courses in a sense. They are not compulsorily taken by Hong Kong students. This is perhaps surprising given that the bilingual status of Hong Kong is well established. We see in the free schools in Hong Kong UCHK and CUHK, we saw a few number of electives in these areas. In the LLB, I think there's only the use of Chinese in Law 1 by Hong Kong U and a legal Chinese course in City U, which I found to be compulsory in sometime in 2012 or something, but I don't think it's compulsory anymore now, as I read the latest regulations and syllabus. In the PCLL, the practice level, the postgraduate certificate in laws where we take the exam for qualification as lawyers. There are courses indeed. So there's the use of Chinese in legal practice and CUHK. I think there's some kind of writing and drafting programs in Chinese, so to train students in these areas. However, they are again electives. So it's perhaps surprising that students don't actually receive some kind of systematic treatment or education in terms of these areas. And most importantly, in terms of Chinese oral advocacy, in terms of speaking in Chinese on something legal, there's virtually no training. And similar observations are made for legal professionals when we talk about continuing legal education, continuing professional development. It's virtually absent, as there's literally no training to legal professionals on how to improve or to maintain a proficient level of language. And you really realize there's some gap between ordinary language usage, which we all do, and legal language usage. I'm not trying to make a distinction between legal Chinese or English being more difficult, but in a sense, there's something to be done in terms of thinking about legal language in use. For judicial officers, there's some kind of workshop, Chinese judgment writing workshop, as shown in the annual report recently. However, it isn't run very frequently for judges, and it takes, I understand that it takes quite a workload. So I want to now focus on the new course that I and my co-instructor, Mr. Evan Cham, has been developing for the next academic year, which is a course on legal language in Hong Kong, issues and directions. It is an advanced elective course and should be offered in law faculty, and we limit the enrollment to law students. And that kind of echoes our view that law students need to have a more better awareness in general in terms of language. So we assume some kind of good understanding of the legal processes and the reasonings. They having studied law for 2 or 3 years, they would have had some knowledge of how the legal process works in general. And we assume, therefore, for law students, they don't really know about linguistic theories and frameworks in general, because after all, they come from a legal degree background. And we assume that they're reasonably proficient in somehow in languages in Hong Kong, in general, Chinese and English, in order to understand all the materials that we're going to give them in the course. So with the aim in mind, with the aim and the audience of legal students, law students in mind, we kind of divide our readings into 3 types of materials. The first type is legal materials, and they are usually cases. So we ask students to reflect on these cases based on the legal reasoning process. So after having studied law for some time, they should have known why is this decision reached in a particular case and how is the reasoning process of it. So I think they will be fairly, we assume, or we hope that it will be fairly familiar for them to do so. And there's the linguistics materials, which introduces potentially relevant theoretical frameworks to the picture, for example, on sociolinguistic theories such as power, discourse analysis, conversational analysis, translation equivalence, and so on. These will be relatively unfamiliar, we assume, to the law students. However, we see that it might be potentially relevant, and the aim is to have them apply these kind of linguistic materials into law materials. And that comes to the third type of materials and readings that we give to students, that is some kind of legal linguistics materials. Given the recent development of this interdisciplinary field, we see there are relatively few studies on them, but we can give students a sense of how these interdisciplinary studies are conducted, to see how previous scholars have looked into these kind of issues, either from a Hong Kong context or from another context. Although, as said, because the course is legal language in Hong Kong, we'll probably focus more on the local context. So it might be good to substantiate this with kind of examples here. So, for example, in the lesson, we're going to design a module on court interpreters. So we're focusing on, again, the three types of material. So we'll give each type of material one compulsory and a few optional readings for them. So these kind of readings, we are hoping them to think about in more detailed manner. So we set up a case, the Gutierrez case, which talks about the interpretation standard that is expected of a court interpreter, a fairly comprehensive overview of the treatment, and law students are supposed to get to the point about what's happening in this case. Why do the judge think that way? And then, but we also encourage them to look further than the legal reasoning process and to look at linguistic development. So we have a linguistic reading by Anderson on the role of interpreter in an interpretation or court setting. And then we have a specialized work by Eva, a colleague in the Hong Kong School of Chinese, on how judicial interpreting is carried out in Hong Kong. And therefore, with this kind of intertwined domains of reading, we hope to give students a fairly comprehensive sense of what's happening, for example, with this particular actor of court interpreters. And then we give optional readings for them to explore further on these issues. Another example I have here is on advocacy. So I'm trying to look at how lawyers and litigants use language. Again, we give them a case. We give them something to look about, a Chinese case, which I think quotes some of the evidence or the discussion between the judge and the litigant. And therefore, it's interesting to see how language is used in a real life context. And then we have some kind of linguistic model for them to apply, in a sense, or to think about how does it apply or not apply to the particular case at hand. And again, we have some kind of legal linguistic material which helps them to put things into context and to further explore the area. So in general, the course design is hoped to give them some sense of idea, both from the legal and linguistic framework. We assume them to be more proficient in one, but then we hope to help them to integrate these kind of issues together. And we take an issue-based approach in helping students to understand. Of course, this course is not yet offered. It will be offered in next year. So I'll be happy to report later on, after this launch, on how this goes on. But this will be our course design. Turning to assessment, we kind of have participation, we'll group presentation and final assessment. The final assessment is, of course, designed to help students to reflect critically on what they learn individually. That's the final essay. But then we also have a group discussion thing where students are intended, we intend students to make some opening discussion for each of the thematic sessions. So for example, I've talked about court interpreters just now. So a small group of students, for example, 3 to 4 students, will form a group and discuss or to reflect on the compulsory readings and see what are the connections, tease out the connections and interactions between language and law in these areas, and build on the foundation for the subsequent discussion within the session or within 2 sessions about how these language and law issues interact. And therefore, this is also examining the students' ability to integrate different concepts and disciplines into a single case. And this also reflects as a case study to interdisciplinary legal education in general. I'll be happy to talk more about the case, but I want to turn now briefly to another part of my presentation, which looks at student-oriented legal journals, students playing a part in legal editorships and so on, in order to get to a better understanding and awareness of language. So I focus here on 2 journals, Hong Kong JLS, the Journal of Legal Studies and the City University of Law Review, both of which are student-run journals. So students in these journals are proactively engaged in selecting, editing, and publishing articles, and particularly so in these student-oriented legal journals. As previously chief editor of the HKJLS, I can talk a bit about my personal experience, but I know time is limited, so I'll just focus on a few things. So peer review of student editors, again, student editors are used are employed in the sense they are going to evaluate a particular article, focusing not only on the content but also on language issues. And when they go on to edit the approved or the accepted articles, they check on the language, they check on formatting, and they are at liberty to engage in dialogues with authors by email, by correspondences, to discuss and clarify these issues. So when there's a particular point that isn't clear in terms of language, they have the chance to clarify. And that also trains their diplomacy skills, communication skills, and dealing with these language issues in a sense. The City University, interestingly, has an optional elective course for the editors. And I want to focus particularly on the second assessment method of this course, which is by a research paper. So this kind of research paper is an individual exercise where the student editors individually produce a new research article based on what they have learned in the language process. So with the journal editing process, so they learn about the language, they learn about how to write up a relatively good journal article, and then they will apply this into practice. And that's why, and I say this will provide a valuable opportunity for them to transfer their academic writing and editing skills acquired from the journal editing experience and facilitate training of them into for law students in language. I have published an article, I will be publishing an article very shortly in the Learn Publishing Journal, and if you're interested, you can look more into that as well, where I explain more. So briefly on the last point about research assistantships, again, I'm focusing here more on extracurricular activities than intracurricular assessment rubrics, where we can certainly impose some kind of language-related requirements and marking criteria. I'm not the expert in this. I know the CUHK has organized previously a teaching and learning seminar on this. Perhaps we'll skip that, but just on research assistantships, which is another extracurricular activity that students might be engaged in. Research assistant supervisors can provide substantial writing tasks or tasks that RAs have to think about and write about. And academics, as more experienced actors in legal communication, in communicating legal ideas, they are also helping student research assistants to be more concise, precise, and effective in terms of communicating legal ideas to elsewhere. And this kind of mentorship is not only legal in the sense that it provides new legal knowledge to students, but also language mentorships, because through reframing the article, through revising and refining details within a certain writing task, is also kind of mentorship where teachers, RA supervisors transfer language knowledge or communication strategies to their research assistants. So I'm concluding here, there should be general awareness of multiple language issues in the Hong Kong legal context. I've covered new course design, as well as how language and law should take a more important role in Hong Kong's legal education, as well as to make use of extracurricular activities. But what can be done in the future? What can be done in the future? So the general idea is to create a holistic development and awareness of language in legal education, not only in terms of being aware that there are these kind of actors, languages at work, but also the actual application of language in the legal context. There's also a need for increased variety of a Chinese training, or even a compulsory training of Chinese, because as we know, Hong Kong is a bilingual legal society, and it's surprising that it's not given the same accord as legal English, where we have compulsory courses on legal English. Why isn't the same done for legal Chinese, where, and noting that a substantial amount of cases are conducted in Chinese? How about Chinese advocacy in general? We don't see any of these now, but should this somehow be done in the PCLL level or even the undergraduate level? And as well as legal practitioners, which I know is not the focus here, but I mean, it's generally a holistic picture that you help law students and legal professionals to get in from a legal background to understand more about language as well. That's the end of my presentation. I look forward to discussing any questions, issues that you might have in mind Thank you.
Thank you, Mr. Wilson. And the most captive point of the presentation was that why not legal Chinese as legal English? So it gives us an idea or thought. And similarly, now in other parts of the world also, the same idea is under consideration and being discussed. So meanwhile, let's have the question that's there in the chat box. So I hope there's a very big question from Esther. So getting into law is a very competitive process, and historically some of the prime candidates would be those who have attended international schools and or overseas boarding schools. And given that most would have been mostly raised by a domestic helper speaking English, even their basic Chinese language skills may not be sufficient. This is a bit of blunt question, but we are now tripping these students up by requiring them to participate in legal education in Chinese, whereas the legal system is still the common law. So, Mr. Wilson, would you like to?
Yes, thank you. Yes.
Yes.
Can I just start by saying that I think it's not necessary to equate common law with English and non-common law or different Hong Kong law as Chinese. It's not really the equivalence between language and the legal system. And you can't say, well, some have argued, a few scholars have argued that Chinese is not suitable to express common law ideas. But is that really true? I mean, or else how does Hong Kong survive the past 25 years of legal usage in Chinese? There's progressively steps that are made in the past few years. The Department of Justice making English Chinese glossaries in a more comprehensive manner, and we have bilingual legislation in every of our statute. I mean, it could be true that there are difficult ideas to be expressed, but it doesn't mean that because the common law, we still practice the common law, doesn't mean that we therefore have to use English in a sense. And second thing is that I think it might be overworrying to say, because I think under the new system, the Hong Kong DSE system, students are required to get at least a level 4 in Chinese language in order to get into any law programs in Hong Kong. If you are a foreign language speaker, I mean, coming from a non-JUPAS route, then probably they can be replaced for something else, elective course, for example. But however, for local students, I mean, I think the domestic helper worry will be too much. I mean, I think law students certainly, and you have to give the confidence to them that they have the language ability to conduct legal affairs in Chinese, and therefore we have to provide the necessary and proportionate training to them. I'm not saying that we have to do a lot, but at least something in order to correspond with the current legal situation in Hong Kong. Thank you.
Okay, so friends, we are running good with a good space of time and keeping good pace. And now, meanwhile, we can take one more question. How could Chinese judgments contribute to the development of broader common law? Over to Wilson.
Well, it's firstly the use of Chinese in common law context. Just now I skipped a slide, but I've tried to show different Chinese translations to the same term, mens rea, in criminal law, which shows that just how creative judges can get in terms of using Chinese terms. And therefore, the first thing is that we need to have a more consistent and systematic account of Chinese judgments in Hong Kong. We need to look at them and see, are they considered language problems in a sense, or are they considered some kind of more creative or consistent use of language in legal context? After that, we can see an increased usage of Cantonese and Chinese in judgments, and then we can therefore develop an account of common law in terms of Chinese. And that's what I meant by saying that common law can be translated and used and expressed in Chinese. And that's the important part of Hong Kong as well, because it has a bigger role to contribute to the common law world as well. If we have Chinese common law concepts can be expressed in Chinese, then it also help, for example, mainland scholars to understand what's happening in Hong Kong. So I saw that Mr. Roza is posing a problem, so I'll let him finish, if you don't mind, Professor Roza. So he's saying that Chinese judgments are selectively translated into English by the judiciary and then can be found in Norway online. That's true. However, it's so selective, and I feel that it's so limited to very particular cases, which raises great questions of public importance. I know that some colleagues of mine are investigating into a kind of machine-based translation of judgments, the quick translation of English judgments in general into Chinese, because we can't have that much manpower to do that. And I mean, it's also certainly a way forward to have a more expansive usage of Chinese in the common law as well. So it will be indeed a welcoming trend if the judiciary or some other stakeholders will be willing to take this up. However, it seems that until now, the judiciary is fairly limited in terms of the resources devoted into these kind of language issues. So the future is bright, but just that we need to work more on, and that's the whole point of this presentation. By when I say highlighting the importance, it's already important, and we have to do a bit more in order to get into the optimum performance of many languages in the Hong Kong multilingual legal setting. Thank you very much.
Thanks, Wilson. And friends, now we can take up for the last presentation from Mr. Tsega Chimdessa Fekadu from Chinese University of Hong Kong, who will be speaking on, if I'm not wrong, third world approaches to international law as a pedagogy, opportunities and blind spots. Over to.
Okay. Hello, everyone. I hope everybody can hear me. My name is Chimdessa. I am a second year PhD student at CUHK Law. My talk is about TWAIL. TWAIL is short for a third world approach to international law. So as someone who has been teaching international law for 5 years, throughout this presentation, I will also incorporate my experience of teaching international law in light of TWAIL pedagogy. So first, I will talk about what TWAIL is, followed by using TWAIL theory in classrooms as a pedagogy. I will also highlight the challenges while using TWAIL in classrooms, and I'll finish my presentation by providing some concluding remarks. Let me start by clarifying when I talk about TWAIL, I'm talking about the modern version of TWAIL, because TWAIL has been here actually for a long period of time, like in the form of new approach to international law or radical approach to international law. But in this case, I'm talking about TWAIL in its modern version, which started in 1997 when scholars from law schools from third world countries met at Harvard to come up with a way to contribute more to the teaching and the learning of international law and bringing about an alternative worldview to international legal scholarship. I am usually very skeptical of defining TWAIL, but for this presentation, I will just adopt the definition by one of the prominent TWAILers, which is Professor Chimney. In his work, TWAIL, the Manifesto, he defined TWAIL as an attempt to understand the history, the structure, and the process of international law from the perspective of third world states. So it is crucial to highlight from this definition that one, history is at the center of TWAIL because TWAIL as a theory and as a methodology uses historical factors. It could be pre-colonial, colonial, and post-colonial historical facts to challenge the existing international legal scholarship and the international legal system in general. It's also important to clarify the term third world in this case. Traditionally, if we look at the orthodox or traditional version of TWAIL, the term third world was used more in its geographical sense to describe the people who live in the global south. But this has transformed through time to represent any section of the society that we consider are underdeveloped, underrepresented, and marginalized within the context of the international legal system. Coming to the objective of TWAIL, TWAIL is generally about empowerment. It's more about empowering those in the global south to tell their stories from their own perspectives and provide an alternative perspective of international legal scholarship. The main criticism of TWAIL has been that it focuses on criticism. I want to address this before I go into TWAIL pedagogy, because specifically if we look at TWAIL in its modern version, it goes far beyond criticism of international law, because TWAIL has become about understanding the foundation of international law, critiquing it, but at the same time providing a more meaningful solutions so that there will be an international community that speaks, an international law that speaks for all members of the international community. So what is TWAIL pedagogy? TWAIL by itself is a recent phenomenon. Like I said, in its modern version, it developed in 1997. TWAIL pedagogy is actually more recent. It was actually first coined in 2010 by another prominent TWAIL scholar, who is Mohten Al-Assar. TWAIL pedagogy, TWAIL teaching in general, is about applying analytical tools of TWAIL as a social movement or TWAIL as a theory while teaching international law courses in classrooms. So it could be while teaching general international law, or it could be while teaching specialized areas of international law. So it is specifically about using the analytical tools of TWAIL itself in the classroom while teaching international law courses in general. So how can we do that as teachers of international law? How can we apply TWAIL as a pedagogy in classrooms? The first tool or the first mechanism of doing it is just diversifying the law school curriculum. This is mainly about reviewing the law curriculum to include indigenous knowledge, indigenous voices, and indigenous scholars. For instance, while I was teaching public international law, the easiest way of doing this is adding more reference materials or more textbooks in addition to the mainstream international legal scholarship. Because when we teach public international law in general, I think there are a few books that almost all law schools universally use. It could be Malcolm Shaw or it could be Brownlee. So what I did is at least adding more a third world perspective book that provides an alternative worldview from a third world perspective that can at least provide an alternative at the same time, a challenge to existing textbooks on teaching international law. This can be done while teaching human rights law, for instance. We can use human rights law, and then we can provide additional material that provides about, that talks about international human rights law from a third world perspective. Another tool of using TWAIL in classrooms specifically is adopting what we call this emancipatory methodology, which is part of a TWAIL social movement or a TWAIL theory itself. Because when we teach international law, it has become very common to use a more traditional banking education in law schools. Banking education is a system in which we use a passive view of our students so that we teach them about the content of international law, why these laws are binding, and kind of preparing our students to implement or interpret these lessons when they go to the real world. But emancipatory methodology is more than that. It's more about treating our students and empowering them at least to deconstruct and reconstruct the main legal arguments of international law. And one way of doing it is using historical, socio-political, and moral issues when we teach international law. Let me share my experience. For instance, while I was teaching public international law in 2017, what I did was I used mood and simulation exercises for students at least to use extra legal considerations to justify legal arguments. I remember a specific exercise using the war in Crimea in 2014, for instance, and dividing the students into groups so that they can argue on behalf of Russia and on behalf of Ukraine concerning the war in Crimea. And that actually is eye-opening when we look at the amount of students that took positions against what we thought was at the time a breach of a norm of jurisprudence under international law. So using mood and simulation exercises are actually very important when we are using TWAIL as a pedagogy while teaching international law in classrooms. Another important approach in TWAIL pedagogy is engaging in interdisciplinary dialogue. I think lawyers, including international lawyers, are always treating law schools as places of an objective value system that does not help in most of the cases, because specifically when we are teaching courses of international law, whether we like it or not, we engage in political exercise. It might be talking about war and peace. It might be talking about trade. It might be talking about investment. In most of the cases, while teaching general international law courses, we engage in political exercise. So the assumption that teaching law should be objective, should be value neutral, should be apolitical, it is in most of the cases inconsistent with teaching of international law. So it is always very important to have an interdisciplinary view of legal issues, specifically within the context of international law. Because the more we use or the more we stick to this traditional view of the law schools, I think we are reinforcing this established hierarchy of legal education as opposed to reforming it. Like I said, when we talk about interdisciplinary dialogue, it's more about adding courses from social science, humanities, and other relevant disciplines that can give our students a more holistic view of legal arguments or legal issues within the international legal system. Another important tool, specifically when using TWAIL, is what we call developing TWAIL resource portals or platforms. These are simply collection of indigenous sources or materials to which international law students have access to, so that they can be exposed to international visions, alternative visions and ideologies. For instance, in Africa, we usually use two main platforms in this aspect when we teach international law. The first one is a work by the African Union Commission on International Law, which is engaged in shaping international legal scholarship on the basis of indigenous knowledge. If we look at the work of the AU Commission on International Laws, they come up with interpretive guidelines, for instance, in terms of understanding international instruments, specifically international human rights instruments within the African context. Also, we have another portal developed by the Pretoria University, which is the Pretoria University Law Press. Even though its main focus is on public international law and human rights, it provides it exposes our students at least to have a more contextual understanding of international legal issues, including human rights issues. I think here it's also important to talk about the TRILA project in Asia. It was a project run by the National University of Singapore Center for International Law. TRILA is short for Teaching and Researching International Law in Asia. The project published a report in 2020 where it actually revealed fascinating findings when we talk about teaching international law in the Asian context. One of the findings is, for instance, the law schools in Asia Pacific, they usually have international law courses, which are mandatory when we talk about general international law. But when we talk about international legal courses, which are contextualized to ASEAN, for instance, I think less than 20% of the respondents of the law schools in Asia Pacific said that ASEAN-oriented courses in the law schools are optional as opposed to courses on general international law. This actually shows how non-contextualized and in some cases out of touch the law school curriculum is when we talk about teaching international law and contextualizing it to our own socioeconomic and political realities. So what are the main challenges in having this approach of this TWAIL pedagogy in classrooms? Obviously, personally, I have faced different challenges in applying it. The first one is engagement problem by TWAILers. This is mainly about the lack of reference books, the lack of textbooks that are TWAIL oriented. In particular, when we teach public international law, I think there are a few books, but when we teach specialized areas of international law, for instance, international investment law, international trade law, we find that there are very few articles or books that we can assign to our students. So as TWAILers themselves, if TWAILers, including myself, if we take TWAIL seriously, I think it is always important to engage in more production and publication of books. This is especially very worrying because TWAIL has become very important to theories of feminism, theories of sex, and theories of sexuality. For instance, intersectional feminism is grounded in TWAIL. So if we do not have enough textbooks, enough materials that we can ascribe for our students, I think adopting TWAIL pedagogy in classrooms will be very challenging. Another challenge, which is also a criticism usually forwarded by non-TWAILers against TWAILers, is the risk of over-historicization of international legal education when we use TWAIL in classrooms. As I described at the beginning of my presentation, history is at the center of TWAIL. So we usually use historical facts to either corroborate or negate arguments in international law. This criticism actually has to come with a caveat because I think this criticism goes back to how we view the responsibility, how we view our responsibility as international law teachers. What is the role of an international law teacher? Is it just being a technocrat and describing or at least educating our students about the content of international law? Or should legal education involve some sort of social activism, particularly by using historical facts for the purpose of addressing the issue of global justice? It could be environmental justice, it could be racial justice, it could be criminal justice. So this criticism should always be taken with a caveat, but I think it is important, especially for law schools in the global south, to have to incorporate value of activism, to inculcate value of activism to international law students, in addition to teaching our students about the content of international law. But obviously, balance is very important in this aspect because we can see the recent backlash, for instance, against the notion of critical race theory, even if it's not specifically to law schools. We see that there are some sections of the society who will always be unhappy about using historical factors for the purpose of attaining a criminal justice or global justice or racial justice in some respect. So TWAILers need to be very cognizant of that fact while teaching international law to international students, to international law students. Another challenge we face is that TWAIL by itself is very transformative. It is a very extensive undertaking for international lawyers. It requires psychological and institutional reform. And this is actually very difficult when we look at the nature of law schools in the global South in general. This is because international law teachers or international law administrators in most of the cases have studied in the West. So when they establish law schools or when they design curriculum for those schools, it usually mirrors institutions and countries where they studied. So this would be another challenge, particularly to kind of deconstruct or decolonize the curriculum in the global South and have a TWAIL-oriented curriculum when we are at least establishing a curriculum or establishing a law school for international law teaching and learning. This is also very difficult, taking into account the fact that we always have limited resources, specifically in global South, to engage in extensive research and publication in the area of a third-world approach to international law compared with other theories or other areas of international law. And finally, there is a criticism by non-TWAILers that usually as international lawyers, when we adopt TWAIL pedagogy in classrooms, we are becoming international lawyers, encouraging international law fragmentation itself, which I think kind of feels, which is kind of valid at face value, but when we look at the foundation of TWAIL by itself, TWAIL has the notion that we have to be able to critique the legitimacy, the neutrality, and the foundation of international legal system as it is. For instance, I can mention a relatively recent book published by Antia Roberts, and the topic of the book is international law international? And it has a fascinating finding there is a fascinating finding in the book where the book uses case studies of the 5 permanent members of the UN Security Council to describe how international is actually international rulemaking in relation to specific international transactions within the international legal system. The book has a finding that international law is really not international, rather it's more about being dominant within the international legal context. So if we look at the Anglo-American legal system, the French legal system, they are very dominant in most of international transactions within the international legal system. But the book also finds that recently there is a changing phenomenon, there is a gradual change in international legal system where we see some non-traditional areas or non-traditional players in international law having or at least contributing to new rules or emerging rules that challenge the rules of international law that we thought were very much well settled and very much well established. For instance, we can use this in international maritime law or in the law of the sea by looking at the South China Sea and how the traditional rules of the maritime law or the law of the sea is being challenged in some parts of the world in general. So this criticism of international law fragmentation should be actually seen from the fact that international law has never been static. It has always been changing and it will keep changing. So I think it is important, or at least it is worth exploring, to question whether international law is legitimate or not, and to at least have a room for TWAIL within the changing international law landscape. Finally, as a conclusion, as a TWAILer, I would be the first to admit that there is a tendency by TWAILers to consider it as a panacea for problems of international law, which is not the case, which is far from the truth. But when we look at TWAIL, its theory or its foundational arguments based on critique, based on providing alternative scholarship to international law teaching, I think it is very crucial and very beneficial to both teachers and the students of international law. Like I said, I want to emphasize the fact that if TWAILers are very serious about TWAIL pedagogy, it is very crucial that we engage in the production of more textbooks, more articles, and more reference materials for TWAIL scholars across the global south. Thank you very much.
So thanks, Chimdessa, for this brainstorming presentation. So friends, if you have any queries, because we have still 1 to 2 minutes left for concluding the session. And meanwhile, I would like to express my gratitude towards all the participants and presenters who had helped me to conduct this session successfully and completing it within the stipulated time. So the papers presented were very brainstorming and giving us new ideas to think upon, to deliberate, and then exchange. So learning through exchange. So I'm thankful to all of you for making this session successful, the presenters as well as the audience. And at the same time, on behalf of the presenters and audience, I'm thankful to the Chinese University of Hong Kong for giving us this platform to learn by sharing and exchanging our views on the directions of legal education.